Good afternoon and welcome everyone to this month's Employee Benefits Compliance webinar. I am Jenny Bedeau with Assurex Global and I am glad you could join me here today. Today we will hear from the Benefit Comply team on spouse and dependent eligibility. But as we're kicking off today, I'd like to start by asking all of you a couple of polling questions. You'll see those pop up on your screen here. As we are approaching annual benefits enrollment for many companies, we have a couple of questions to ask you on that topic. So first, we're curious, do you have an active or passive annual enrollment process? If you're not familiar with those terms, active means that you require employees to complete the enrollment process and elect benefits every year, even if the employee isn't making any changes. And passive means that the employee's existing elections roll over year to year with no specific action needed by the employee for most benefits to remain in place. You'll also see a question about how long your annual enrollment window is open. You'll see several options there. Please select the option that applies or most closely applies to your company's practice. As you are submitting your responses, I will thank your local Assurex Global benefits advisors and consultants for making today's webinar possible. And we do welcome your questions today. If you have any questions at any time throughout the presentation, please submit those over to us using the Q&A function at the bottom of your screen. And we do record these sessions. A link to the recording, as well as a copy of the presentation slides, will be available early next week from the benefit advisor who invited you here today. And I'll also drop a link to today's presentation slides in the chat section towards the bottom of your screen here in just a couple of moments. Let me check on our polling results. It looks like a few responses are still coming in. I'm going to give it just a moment. A sneak peek would tell me that just over half of you have an active annual enrollment process, but it's a really close kind of match between active and passive. And it looks like 2 weeks is kind of the most common response for how long that annual enrollment period is open, but I'll give it just a moment and I'll share the official results out with you. And as those final responses are coming in, I will mention I do have one related polling question that I'll have for you during my closing comments, so be sure to stick around for that. All right, let me close out this poll. I'll share the results with everyone. So you can see here where we landed. 54% of you have that active annual enrollment process. 46% have passive, certainly pros and cons to each of those. And as far as the annual enrollment period, as I kind of teased you, we have 2 weeks as kind of the clear winner, 61% of you with kind of a variety across the other options. So as always, we appreciate you taking a moment to respond to those polls. And with that, let's get into today's content. I will now welcome our presenters. Joining us from the Benefit Comply team, we have David Flotten, Senior Consultant, and Amanda Olib, Senior Consultant. David and Amanda, I will turn things over to you.
Thanks, Jenny. Hi, everybody. My name is Amanda Olib, like Jenny stated. So today we're going to be talking about spouse and dependent eligibility. Just a few housekeeping items. I see a couple of you have already figured out how to use the question and answer box. We will be watching those as we go through the presentation. We're going to try to get to as many questions as you have, but we typically aren't able to answer all of them. We're going to do our best. If you have very specific questions to specific employee-employer type situations, we might not be able to answer them because we might not have all of the necessary information, but again, we'll do our best. So, like I said, we're starting today with spouse and dependent eligibility. And before we kind of jump into the specifics for each of these items, so spouse and dependent separately, we kind of wanted to talk to you about big picture. So you can see here on the slide, the point that I really wanted to make was, you know, we get questions all the time. Is so-and-so person eligible as a spouse? Can this person be added as a dependent? And the answer really is going to always come back to the plan documentation. That is where the formal definitions for what the plan considers an eligible spouse and dependent, that's where those definitions should be held. Now, obviously, when it comes to how those definitions should be formed, there are going to be all kinds of different considerations. And all of those considerations, you know, along with cost considerations and employee relation considerations, so federal requirements, state requirements, carrier requirements, all of those things are going to go into the decision-making process when it comes to which individuals should be eligible as a spouse or dependent. And then all of that should be captured in the plan document or summary plan description. And that's how you would go about answering the question, is this person eligible as dependent? So again, really, we wanted to reiterate plan document, plan document, plan document. If you take away one thing from today, that's what we want you to take away. Look at the documentation. Reason for that is that if you're an ERISA plan, you're required to administer your plan by the terms of the plan document and SPD. SPDs are supposed to have eligibility language included in them. So you put those two together, and that means that document is supposed to have eligibility language, and you're supposed to follow it, right? So that's why we're always going back to the plan document. So if you're non-ERISA, you may be thinking, so does that not apply to me then? Do I not have to check documentation? Even if you're a non-ERISA plan, typically the plan is going to be administered by some kind of documentation. Now, the formal plan document and SPD requirement isn't going to be there because, again, we're not ERISA. But just thinking practically, it's kind of hard to administer a plan if you don't have some kind of document setting out the terms of the plan. One of those terms being eligibility specifically for spouses and dependents. So we're going to go ahead and put that out there and say, even for non-ERISA plans, at the end of the day, our biggest thing that we're looking at is plan documentation. Okay. So I alluded to this already. Employers really do have broad control over which individuals are going to be dependent or eligible as dependents on their plan. We talked about this earlier. Obviously, you're going to have federal, state, and carrier requirements along with that. So that is going to slightly diminish the amount of control that employers have. It should be noted also that, so in general, you know, if you have a fully insured product, the contract that you're going to get from that carrier, that is essentially what you should look at as the outline for every possible iteration of dependent, right? It's supposed to be a maximum. You shouldn't ever include eligibility in plan documentation or in practice, right? So you should never offer coverage to someone that would include a definition that is broader than what the carrier is permitting in their contract. Essentially, you don't want to offer coverage to people who are not considered a spouse or dependent by the carrier, or if you're self-insured, stop loss carriers, contract and definitions. Reason for that is, you know, you might not have that protection for the claims anymore. The carrier or stop loss carrier might not actually be on the hook to make those payments. But you as the employer, since you made an offer, you know, presumably the employee, you know, expected to rely on that offer, you may actually be required to still cover those claims, even if you don't have that protection that you were planning on, as in the contract with the carrier or the stop loss carrier. The other thing that we wanted to point out is the other reason to strictly follow plan eligibility terms is because if a plan makes a habit of not following the eligibility terms as outlined in plan documentation, it just kind of leads to the perception for other individuals that the terms that are outlined in the plan's plan document aren't really what is controlling the eligibility. So in other words, that there are different eligibility terms in practice. If an individual who feels that they should be considered a dependent based on how the plan has been practicing in the past is seeing other people be enrolled and say, I think I should also, that's where those kind of claims come from, right? So that's why it's important to strictly follow your plan eligibility terms in plan documentation.
Maybe just make one more point there. You mentioned, you should never expand your eligibility beyond what is in the carrier documentation. But as we do note there, it is often possible to narrow it. And just to give an example of what I mean by that, we worked in a state where the fully insured carriers would not put spousal carve-outs into their plans because they said state law requires we cover all spouses. So if we had an employer with a fully insured plan who wanted to do a spousal carve-out, what we would do is create a supplemental wrap document that said, the eligibility is language is what's in the certificate, except that spouses who have coverage available through their own employer are not eligible. So that's an example where you can narrow what the carrier has put in the document, but you wouldn't want to go the other way. So for example, if the plan document said spouses are eligible, but said nothing about domestic partners, you wouldn't want to just unilaterally start allowing domestic partners on the plan.
Exactly. Perfectly said. Thank you, David. All right. So who are we talking about, right? When we're saying dependents, I was actually kind of, when I was titling the presentation and the content piece that I'll go along with it, I was thinking about, because we say dependents, right? And this is titled spouse and dependents. And really, I think dependents sometimes can just be kind of an all-encompassing term for any individual in addition to the employee who's being enrolled. But we've just gotten used to saying spouse as, right, like the employee's partner, and then dependent kind of in reference to children. So that's kind of what we're going to stick to today when we say just spouse and dependent as the bold. We kind of mean anyone in addition to the spouse, but we're going to kind of break it down a little bit more granular level here. So we could have spouse. This could mean legal sex spouse, or legal spouse typically means same-sex spouse, excuse me. So if you see a definition in documentation, it just says legal spouse. We've gotten the question a few times, do I need to specifically write in there same-sex spouses are eligible if we want to make sure that's the case? Nope. Legal spouse will cover it. Same-sex spouses are legal spouses now. Common law, we'll talk about domestic partners. We already got a question in there about domestic partners. Don't worry, we will cover. We also have the children category. So for this, we're talking about natural stepped adopted, even children of domestic partners, we're going to go ahead and place in that category, legal guardians, disabled adults, foster children. And then finally, our last category there of additional possible dependents. So we have tax dependents at the bottom. Obviously, tax dependents can encompass a wide variety of different individuals, including several of the individuals that are already on the screen. And then we also have parents and grandchildren kind of as the ones that we see most commonly included outside of those spouse and child categories.
Maybe just emphasize this is just an introductory slide of possible dependents. We will talk, we're not saying that all of these people are automatically dependents. We'll talk about as we get to each section, which ones you really have to include, which ones you don't include, and which ones are common or uncommon.
Yep, this is exactly, thank you. It's kind of more just, it's a brainstorming slide to just kind of see it all out there, just all of the potential people that we might be talking about today. And now we're going to just talk a little generally about tax qualified status. So when we're talking about dependent coverage, there really are kind of two different questions, right? And I mean, not just dependent coverage typically for the employee too. So we've got the question, is the person eligible for the coverage? And then we have the question, okay, so they have the coverage, is it considered taxable to the employee? So I wanted to just kind of provide you, because the rules they can be a little bit complicated, but I wanted to provide you with there's three kind of categories of dependents at the top of the screen here. And I wanted to give you just kind of simple definitions. And these three categories, right, are going to be eligible for tax-free coverage for the items listed under here. So we've got legal spouses, children under age 27 as of the last day of the tax year, and tax dependents. Okay, so I want to make the point that second category, the children under age 27, they can be provided tax-free coverage regardless if they themselves are considered a tax dependent, right? Because we have tax dependents listed here in addition to that. So this is an additional category of individuals who can be provided tax benefits on a tax favored basis, excuse me. So when we say that, I think another point to be made is there's a difference when we say tax qualified status. What do we mean? And it's not always the same thing. So the contributions that the employee makes to the coverage, the contributions that the employer makes to the coverage, and the eligible expenses of that coverage are all things that could potentially be taxed. So I wanted to make the point here that these individuals typically are going to be eligible for all of the tax benefits of these items on all three sides. You'll see there are slight differences, really just kind of accounting for the fact that you'll see how flexible spending accounts are not included, or excuse me, HRAs are not included in the employee contribution section. That's because employees don't make contributions to HRAs, right? And so, yes, we have medical, dental, vision, flex, and HRAs. These are all things that are going to be available to those three types of dependents on a tax favored basis. We'll talk about HSAs later on. Those are subject to different rules, both for HSA eligibility and eligible medical expenses. Okay. We're going to move specifically on to the spouse kind of category. I talked about this already. So legal spouse is typically what we're going to see in the documentation. So I wanted to make a few points about what that means practically. So when there is a divorce, ex-spouses are not going to be eligible as an active individual on the plan. I wanted to make that point for a couple different reasons. One, we'll get situations where individuals will come to us and say, well, they got divorced, but the employee is actually subject to this court-ordered requirement, essentially to provide their ex-spouse with coverage. And they'll say, so that means they're eligible and they get to stay on the plan. Not quite, right? So that order is against, or enforced against, really, the employee, not the employer, right? So the court is saying to the employee, hey, individual, you have to provide coverage for your ex-spouse. You need to make sure that your ex-spouse has health coverage. That might mean that the ex-spouse, or that the employee needs to ensure that the ex-spouse is enrolled in the employer's COBRA. Maybe the employee needs to actually pay for the COBRA coverage. That does not mean that the ex-spouse is eligible as an active participant on the employee's plan. The court doesn't have the ability, right, to make that be the case. Another point to make about any legal spouse being the definition. We got questions a lot about legal separation. So where a plan has a definition of any legal spouse being eligible, if someone is legally separated, they're still a legal spouse. Right? So a legal separation in the case of a plan that says any legal spouse is eligible is actually not going to result in a loss of eligibility in most cases. If the plan says any legal spouse, except if you are legally separated, you're not eligible, right? Or put some other kind of conditions on it where that legal separation would result in the person not meeting the plan's definition, then it would be a different situation, okay? Common law marriage is considered a legal marriage. That can be kind of a confusing statement because I think most people know that a lot of states don't actually recognize common law marriage anymore. And what I mean when I say they don't recognize it, what I mean is you can't enter into a common law marriage in most states, okay? However, if you have entered into a valid common law marriage in a state that recognizes that, most plans are going to see that as a legal marriage. And if you just have a legal spouse in there, it will encompass that. Even if you're in a state where you wouldn't have been able to enter into that common law marriage, it's typically going to be okay. So you could decide you wanted to narrow that and say, I don't want to include common law spouses. I never really understood why, but David pointed out to me before, and it really makes sense. If you're an employer who does dependent eligibility audits, you may want to exclude common law spouses, because it's going to be kind of hard to prove that common law status, because at the end of the day, that's kind of the point, right? You're not going in and doing the ceremony. You just may not have the same formal legal types of documentation, which would make it hard to do that dependent eligibility audit.
Amanda, while we're talking about verification, we've had a couple of questions around this very issue, which is, does an employer have to get documentation to verify that somebody is legally married, or can you just take the employee's word for it? If they say they have a common law marriage, or they say they got married abroad, what do you have to verify dependent eligibility?
Yeah. You don't really. And that's the thing, right? So, I mean, maybe you do if you have decided that you do, if that has become your practice and you're enforcing that against past participants. I think it's, it's just not really fair to just all of a sudden change that for a specific participant. And again, you have to follow the terms of your plan documentation. So if you've put it in there that that's required to be eligible, continue requesting it. But yeah, there aren't any requirements. We don't have anything federally that says you need to make sure you get this, and that. Now I will say, if you provide self-insured medical coverage, you may be required to fill out, or you likely will be required to fill out 1095, either form 1095, either B or C. And in that case, you're going to need the social security number or tax identification number of any enrolled dependents. So it's a good idea to request those items. But again, that's kind of outside the common law marriage part. It's more kind of just proving the person exists, I guess. Okay.
On a related note, what do you do if somebody lies?
Right.
They say, oh, this is my spouse, and it's really just a girlfriend, boyfriend, domestic partner, what have you. What do you do when you discover that wasn't true?
So obviously, if they're not eligible, their coverage is going to be terminated, right? If they've never been eligible and they're not losing eligibility, I think it's important to remember that that is not a COBRA qualifying event, right? We're kind of just correcting an issue, and we don't want to be offering, I know employers want to be nice, but we, again, being more broad than what you've been specifically permitted to do is where we get into the area of risk of employers having to cover claims. So, and then the other thing to note with that, I think it just kind of makes sense intuitively in that situation to say, well, if the person was never eligible, why wouldn't we terminate their coverage retroactively? The ACA has come out and said you can't do that, right? In general, that's the rules, that you can't do that. Now, if you think that that employee very much knew the requirements to be eligible, knew that it was important that they were a legal spouse, right? Knew that this person did not meet the eligibility requirements, at that point, you can say that they've committed fraud, in which case a rescission would be permitted. But we always recommend that you talk to an attorney before you retroactively terminate coverage, just because it is kind of highly litigated area.
One final thing on the whole divorce thing, and it kind of relates to what happens if they lie. The other problem you run into is the employee gets divorced and just never tells you. And so this ex-spouse is sitting there on the plan, and they shouldn't be. Any thoughts on or advice as to dealing with that?
Yep, that's probably 2 or 3 times a day. I feel like we get that question in the inbox. So yeah, they just don't tell you. So the thing about this is, okay, we're going to kind of go back to COBRA a little bit here. So at the end of the day, divorce is one of those events in the COBRA regulations where the employee is supposed to be telling the employer when it happens within a specific amount of time after the divorce occurs, in order for that ex-spouse to actually be eligible for continuation coverage. So in theory, if an employee misses that deadline, it's 60 days, right? In theory, the employer could say, well, you didn't hold up your end of the bargain. they're not going to be eligible for continuation coverage, right? Which would mean and also you could potentially terminate retroactively if they haven't been paying the COBRA premium. If they have, it's kind of a different conversation. All of that though is kind of assuming that the employer has been doing COBRA exactly right. What I mean by that is if that employer has not been getting their COBRA general notices out to employees and really to spouses, right? So it should be addressed to the spouse too. The fact that the employee or the ex-spouse has missed that notification deadline is not their fault anymore. Now it's your fault, and you can no longer enforce that notification deadline against them, meaning that if you were to say you're not eligible for COBRA, you're actually now in violation. They could bring a claim against you. So I feel like the question was, what is kind of the best way to deal with that? I guess it starts with making sure that all of your ducks are in line from the very beginning, because otherwise when you're in that situation, really kind of one of the safer things to do is you might want to talk to an attorney who can then talk to that individual and say, hey, here's the thing. You lost eligibility back here. We're going to maybe potentially count that towards your total coverage time for COBRA. Because the problem is if you offer 18 months going forward, you're putting yourself in the position with the carrier, the stop loss carrier, where they might say, well, that person lost eligibility way back here. Why would I agree to cover their claims 18 months from now? Right. So that's a sticky, tricky situation. If you get yourself in that situation, that's why I think at the end of the day, it might be worth it to talk to a lawyer to potentially get that individual to sign maybe a release of claims, because yeah, that can be a highly litigated area. Do you have anything to add to that question specifically?
No, I mean, the only other thing I might suggest is trying to avoid it.
Yeah.
When you're in open enrollment, maybe remind people, only legal spouses are allowed to be on the plan. If you're no longer married, you need to let us know. If you're doing an active enrollment, maybe even make them affirmatively confirm this is your legal spouse, so trying to uncover it before it becomes a huge issue.
Yep.
Easier said than done, I get it, but that's the better.
Yep.
That'd be ideal.
I 100% agree. Yeah. It's okay. I think we so that's legal spouse, right? Domestic partner. This is a really popular question. There are so many, I think, misconceptions kind of out there on domestic partners and benefits. So we're just gonna try to clear up as many of them as we can today. So first of all, domestic partnership is not a federally recognized status. Okay, so there really isn't this end all be all definition of what a domestic partner is. Some states recognize domestic partners status, limited. Some states have registries, but for the most part, it's really going to be up to the employer to determine, one, if they're going to offer domestic partner coverage, two, if they do, to determine what their definition of an eligible domestic partner is. So things that we see included in that definition, things that commonly matter, whether or not the employee and that individual are cohabitating, whether or not they share expenses, that neither are married to another individual. When it comes to asking for proof of that relationship, things that we've seen are, again, registrations in states where that's available, having the employee sign an affidavit, essentially just swearing to the fact that they meet the eligibility definitions. Maybe you're going to prove some of those factors like cohabitation. So I've also seen like they're on a mortgage or a lease together, right? That could also be something. Domestic partners are not eligible for tax-free benefits, okay? Unless they are the employee's tax dependent. Most of the time that's not going to be the case. It kind of because of, typically it's because of the support rule. Typically you're not going to see the employee actually providing that certain level of support for that domestic partner. Because of that, so when we say not eligible for tax-free benefits, kind of going back to that slide more towards the beginning, we do mean employee contribution, employer contribution, and then when it HSA, FSA, HRA reimbursements as well. So if you have a domestic partner who, if you're allowing that coverage, means a few different things. One, you're going to have to determine the fair market value of that coverage provided to the domestic partner. And two, you're going to have to ensure that the employee is taxed on that amount. So that means both the employer and the employer contributions are going to be taxable. When it comes to the employee contribution, that can kind of be done in two different ways. Either the deduction can come out differently on a post-tax basis, or you can take the entire deduction for all of the benefits, employees portion and any other eligible dependents. You can take it all out pre-tax and then essentially just add it back in post-tax, impute it as income to the employee's W-2 at the end. One final note about domestic partners. We're not going to cover COBRA just more generally on this, but I wanted to make the point because COBRA, when it comes to domestic partners, COBRA is just a little bit strange. So only spouses and dependents, really, dependent children is the way that the COBRA statutes word it, are going to be or could potentially be qualified beneficiaries. In other words, domestic partners are not going to be qualified beneficiaries. They're not either a spouse or a dependent child. That means that they don't have any independent right to elect COBRA. In other words, if we have employee termination or reduction of hours, that employee could elect coverage for the domestic partner. But if the employee themselves doesn't elect coverage, or they don't elect coverage for the domestic partner can't elect it for themselves. They don't have an independent right to elect COBRA. So that means at the end of a domestic partner relationship, for example, that's not going to be a qualifying event for that former domestic partner, even though they're losing coverage. Remember I said COBRA, we're talking about dependent children is what they say. So that does mean that if a plan permits a domestic partner's child to be enrolled, termination of that domestic partner relationship could actually be a COBRA qualifying event, but not for the domestic partner, for the domestic partner's child. Okay, because that could be loss of dependent status, which is a COBRA qualifying event. Okay.
All right. Before we move on,
the children, or answer a few questions first.
Well, there's one kind of recurring one, and I'll offer my 2 cents. I'm curious to see what you say. A lot of people asking variations on the theme of how common is it for people to do dependent verification? How often do employers do that versus just taking people at face value, and what's best practice? My sense, it's a sizable minority of employers who do dependent verification. Let's put it, 33%, just to make up a number. I don't have any stats to back that up, but I will say I think it is a minority. The vast majority of employers, or I mean not the vast, but the majority of employers don't ask for verification, but there are large swaths of employers who do. Putting on my lawyer hat, I do think it's best practice to do verification. I mean, we can tell you so many stories of people who lied or just didn't realize somebody wasn't eligible, or all sorts of things. I personally think it's best practice, but I do understand it causes work and employee relations tensions and things like that. So what's your
I 100% agree with that. I've actually thought about this a lot because sometimes I feel lucky to be in the position that we're in, where I get to hear all of these things and then I don't actually have to be the one that fixes it. So I get it. I understand why you don't want to do it, but yes, David, I completely agree with you. I think this is one of the areas, sometimes we'll get on here and we'll say, this might happen. I haven't really seen it personally, but apparently it can happen. This is not one of those areas at all. This is an area where we have seen plan sponsors end up being on the hook for claims that they did not expect to be. So I think it's a good idea. Then again, I'm probably going to kick myself a week from now when we get a million questions about dependent eligibility audit stuff. No, I'm kidding. Please ask us the questions. I do think it's worth it. So.
All right, now let's move on to children. And again, we're kind of using this as a broad catch-all to cover a bunch of different categories within this. As with everything, just to reiterate everything Amanda has said, always go check the plan documents because this is not universal. This is one area we find people make assumptions about who is eligible, and then you go look at the document and their assumptions don't line up with what the document actually says. So if we kind of start, the big category, almost all plans are going to cover biological, adopted children, and stepchildren. Okay. There's really not too much to say here. I mean, I think most of these are pretty straightforward. Just a few general comments. It doesn't matter if the parents are married, they're still the employee's biological children. So, if we're talking, for example, domestic partners, not married, but they have a child together, that child is a biological child of both of those people. Either of them can enroll them on their plan as their biological child. It doesn't matter if your plan has domestic partner coverage or not, it's still the employee's biological child. So marital status, domestic partner status of the parents is irrelevant to whether a biological child can enroll on the plan. When it comes to adoption, adoption is a formal legal process. It does end with a court order that says, this child is adopted by so-and-so. But it's a process. And a lot of times that adopted child will be placed with the employee before the adoption is actually final. And again, you have to check the plan docs. Some plan documents will allow that child to be enrolled as soon as they're placed, even if the adoption isn't finalized. Others require that the adoption be finalized before that child can be enrolled. With stepchildren, a stepchild is by definition the child of your spouse from another relationship. The issue very often that comes up there is when does that relationship end? When is that child no longer your stepchild and thus no longer eligible for coverage? And I think the most obvious example is divorce. Once their biological parent is no longer my spouse, that can't be my stepchild because I don't have a spouse anymore. The harder one, and I have run into this, I've had actually employers yell at me over this, is what happens when the biological parent dies? Is that stepchild still that employee's stepchild or not? You can argue in a very technical legal sense the marriage is over, but emotionally that feels very different than a divorce. So that's, hopefully you don't get into that very often because it is a very difficult situation. But it is something that does come up, and very often, unfortunately, the plan docs are usually not going to help you. And so you as the employer may have to make that decision on your own. Now, if you remember, Amanda said there's no federal law that requires that you cover spouses. When it comes to children, it's a little bit different. We have two federal requirements, which as a practical matter are usually going to mean you are going to cover children. It's not quite true to say you must, but it's a pretty strong hammer, if you will. So, the first thing is the ACA has this age 26 mandate. Now, this doesn't actually require that you cover children. What it does require is that if you do cover children, you have to cover them till age 26. Well, since almost every plan covers children, that means as a practical matter, almost all children are going to be covered until age 26. Okay. This requirement applies to all plans, and all employers, regardless of size. It applies to almost any child as defined by the tax code. Again, assuming your plan covers it. For example, if your plan didn't cover stepchildren, they don't have to, you wouldn't have to provide this coverage. But if you do cover stepchildren, it's got to go to age 26. And probably the most important thing to keep in mind under this age 26 mandate is that you are not allowed to define eligibility for that child based on anything other than the fact that they are the employee's child and their age. And so that means, for example, you can't say if you're over 19 and married, you don't get coverage. If you have coverage available through your employer, you can't enroll on our plan. You have to, you can't say you have to live with the employee. You can't say the child has to be the employee's tax dependent. There can be no other criteria on eligibility other than age. And that is different from pre-ACA days where we did have all those restrictions and more. And so nowadays it is pretty straightforward. Is it the employee's child? How old are they?
No.
That's it. We're done. Okay.
I think that one did take a while for the industry to catch up, though. Every once in a while, we'll still see some of those conditional things in contracts. So, yep, watch out for that one.
Yep. Or employers will say, well, this
Yeah.
child has their own coverage elsewhere. I'm not covering them. It doesn't work. The other federal rule that affects child coverage is the employer mandate or the employer shared responsibility penalties. Now, this only applies if you're an applicable large employer, which means 50 or more full-time employees and their equivalents, with full-time here being 30 or more hours a week. And one of the requirements, one of the penalties under the employer mandate is the so-called 4980 HA penalty. And what that penalty is asking is, did you offer coverage to 95% of your full-time employees? But what it actually says is, did you offer coverage to 95% of your full-time employees and their dependent children? Okay. So in other words, if you're an ALE and you decide, you know what, I don't want to cover children at all, under 4980 HA, you haven't actually offered coverage. And as a result, you're going to fail that 95% test and face a very large penalty. And these penalties, depending on how big you are, can easily reach into 6 or 7 figures. So the practical reality is if you're an ALE, you are going to cover children because the penalty risk is simply too high. There are certain categories, for example, again, you don't have to cover stepchildren. That wouldn't violate this rule. Again, most plans do. So somebody actually asked this right at the start, well, what about children over 26 who are disabled? So these categories are common. These are additional categories of children who it's common to cover, but it's not required. And this is where we talked about earlier about be careful about making assumptions. A lot of people just assume a disabled child over 26 can enroll on the plan, or just assume if the employee is a legal guardian, they can enroll on the plan. That isn't necessarily true. The plan doesn't have to cover these children at all. Because of that, not because they don't have to cover them at all, the criteria they use to determine who is eligible can also vary from plan to plan. And, you know, I was dealing with somebody, well, let's talk about disabled adults first. You know, there's lots of different ways you can define who's an eligible disabled adult. You know, certainly they have to be disabled. But from there, we can have criteria like, can the child work? Who's supporting the child? The employee, themselves, SSDI. Are they the employee's tax dependent might be relevant. Where do they live might be relevant. Do they have a Social Security disability determination? I've seen all of these criteria in various combinations in different plans. And it makes a difference. As I was dealing with a client the other day, they have an employee who has a disabled adult child. It's been on their plan for years. They moved carriers. They switched from one carrier to the other. The new carrier said, fill out the application again. And this time the new carrier said, no, that child is not eligible. The employee is understandably a little confused, saying, well, nothing's changed. They're still disabled. They're in the same boat as before. Well, what had changed was the definition. The old definition under the old plan said they have to be disabled and not able to work. Well, the child wasn't able to work, so that would satisfy. The new plan said the child has to be disabled and the employee has to provide at least half their support. Well, this child was not living with the employee. They were living in a group home. Their rent was paid for with their own SSDI benefits, which included their food. You know, if you think about it, what's your biggest expenses, right? It's living and eating. And so under that criteria, the employee was not providing half of that child's support. And so suddenly the child was no longer eligible. So that definition absolutely matters.
Yeah, I think that one is so interesting to me because really kind of at the end of the day, it falls down to, do they qualify for Social Security, like, which is
Yeah.
not something you would typically think would either make or not make someone eligible as a disabled dependent. So yeah, that one was really interesting to me and just a perfect example of why it's so important to look at the documents.
Yep. And the same is true when we start talking legal guardians. Now, again, the plan doesn't have to cover children where the employee is the legal guardian, but a lot do. The difficulty here very often is there are 50 states and therefore 50 state family laws. And they all use different terms. They have all sorts of different custody arrangements, some of which may be called legal guardianship, some of which may not. A lot of states have informal processes where you can transfer custody or at least parental responsibility without having to go to court. Which of those things are legal guardianships within the meaning of the plan? Usually, legal guardianship usually connotes we need a formal court order, right? It's not just that, grandma took in the kids because mom was going in the military or dad has a drug problem, or as the case may be. Usually you need a court order. But you also have to keep in mind having custody of a child is not necessarily the same thing as having legal responsibility for that child.
Mhm.
And that's usually what we mean by a legal guardian is that person actually is legally responsible for that child. And so you very often, when somebody comes to you and says, I'm the legal guardian, you want to ask for the court order or the other legal paperwork they're relying on. And then you're may have to do a little digging to understand state family law to understand what this is. And I'll give you another horror story here where the employer didn't do that. The employee basically came forward and said, hey, we've taken custody of this kid. Here's this informal agreement. And it was this horrible convoluted thing. There had been a legal guardianship, but not with the employee, it was to somebody else. And the legal guardian was then informally transferring custody to the employee under North Carolina law, but the employee lived in Pennsylvania, and Pennsylvania law didn't recognize. Okay, you get the point. But the employer didn't check any of this. They took the employee at face value, enrolled the child. That child unfortunately ended up having some significant medical issues, racked up 6 figures worth of medical bills. The employer goes to get reimbursed from stop loss, and they say, oh, wait a minute, who is this kid and what's their relationship to this employee? And when they looked into it, they're like, this is not a legal guardianship. This child isn't eligible. And they denied the claims. And the employer got stuck with literally hundreds of thousands of medical bills because they just assumed the child was eligible.
Yeah.
So, going back to our question, should you verify eligibility? Certainly when we get to these two categories, yes. You need
And
to.
I think too, like I think really a point to be made with that one too is, I think there is a difference between checking up on making sure that your employees aren't lying, right? And at least making sure that your employees are aware of what needs to be true for a person to be eligible, right? So even if you're not going to require them to provide you with the formal documents, right? Like at least maybe an affidavit saying like, here are the things, like this is what we actually require. Can you at least tell me that you think that you meet this definition, right? Because I think part of it is the employees don't know either. Like in your example there, it's not like they were trying to defraud the employer. They had good reason to
You're
believe
absolutely
that.
right.
Yeah.
The employee was actually totally upfront about
Right.
what was going on. It
Right.
was the HR person didn't check.
Yep. Yep. Yeah. All right.
All right, so one thing we just wanted to touch on is HSAs and children, because if you remember back on Amanda's slide earlier, we did say HSAs are subject to slightly different rules. And in particular, it has to do with what can an employee use their HSA money for, or who can they use their HSA money for? And the HSA rules are different, and they say an HSA account holder can use their funds tax-free to pay for the medical expenses of the account holder themselves, the employee, their spouse, or their tax dependents. Notice it does not say children under the age of 27. And so what that means is you can have children who are eligible up to age 26 on the high deductible health plan. But if they've moved out of the house or on their own, have their own job, at some point, they're probably not the employee's tax dependent. And the employee at that point cannot use their HSA funds to pay for that child's medical expenses anymore. So it is confusing because the child is legitimately on the HDHP, but just because they're enrolled on the HDHP does not automatically mean the employee can use their HSA funds to pay for that child's medical expenses. Only if the child is a tax dependent. Now there's a trade-off though, which is one of the criteria to open your own HSA account is you can't be claimed as a tax dependent by somebody else. So while that child is a tax dependent, the employee can use their HSA money to pay the child's medical expenses, but the child can't open their own HSA. Once that changes, once the child is no longer the employee's tax dependent, now the employee cannot use their HSA money for that child, but now the child can open up their own HSA. And they can, even though they're only a dependent on the HDHP, that's good enough. And the child can start putting money into their own HSA to use for their own medical expenses. So they do kind of go hand in hand as to how that works.
Awesome. All right.
All right, last category. So these are potential additional categories. I will also say they're not common. It is rare for health plans to cover parents, even if it's an elderly parent that you're caring for. It's uncommon that you're going to cover that. I think one state, California, started requiring that in the individual group market, but not, or I'm sorry, in the individual market, not the group market. But it's very uncommon.
Well,
sometimes plans will cover grandchildren. But again, not common. I saw one question was, well, what if you have a child on the plan as a dependent and that child gets pregnant and has a kid? Do we have to cover that child? Again, usually the answer is no. Occasionally, I think it was one state did say that if the dependent child who has the baby is themselves a minor, then you have to cover the grandchildren until the parent turns 18. So there can be weird, quirky little exceptions like that. But again, this is why you have to read the documents. As a general rule, no, you do not have to cover grandchildren, even if the parent is a dependent child on the plan.
Mm-hmm. And I think have to provide coverage, right? So again, it's like, no, you don't have to. And in fact, you shouldn't. If you're not supposed to, right? We don't want to get caught with those claims.
Yep.
Yeah.
And then the last thing we wanted to put up here is actually almost the opposite. It's not common to see tax dependents being eligible because it can potentially be a really, really broad category of people who would be covered. And so we actually want to make the opposite point. Just because somebody is a tax dependent does not mean they are a benefits eligible dependent. The two are two completely separate and distinct concepts. So your elderly parent who lives with you and you take care of them may be your tax dependent. That does not make them eligible for coverage under the plan unless the plan specifically says so. Okay, so don't confuse tax dependent status. The employee comes to you and says they're my dependent. Well, what do you mean by that? And if all they mean is tax dependent, that does not guarantee them coverage.
Yep. All right. I think that is the end of our scheduled content here. I know we've got some questions. I also know that Jenny wanted to come back in and do another polling question. Should we kind of get through a couple?
Maybe let's answer a couple of questions and then we'll let Jenny wrap up then.
Yep. Let's see. There's a question about just open enrollments. In general, the question is if you can have more than one open enrollment. Not really sure how it's related to dependents, but I'll just answer your question quickly. In general, 125 plan is required to have a 12-month plan year. So you're supposed to just have one. Now, if you have different plan years for different benefits, you essentially have different plans. And as long as each one of them are still having just one open enrollment, that it should be okay.
Somebody asked a question here on the whole issue of a child who's not a tax dependent and having their own HSA. Can the employer in that situation? So let's say employee has an adult child, not their tax dependent. The employee can't use their HSA money anymore for that child. Child opens their own HSA. Can the employer contribute to that child's HSA? The answer is yes, but I wouldn't recommend it because it's going to be taxable income to the employee because that child is not your employee. And so the tax reporting gets messy once you start contributing to the HSA of people who are not your employees. So possible, but not a good idea.
What about court orders for children? Are employers required to consider this a qualifying life event to add coverage for children? So probably in reference here to either national medical support notices or the more general qualified medical child support orders. So yes, in general, employers are supposed to comply with those orders. I'm gonna kind of outline what that does mean and what that does not mean. Okay, so it does not mean employers are required to permit employees to add dependents who are not otherwise eligible under the terms of the plan. Okay. It does not mean that employees or that employers would, for some reason, permit that dependent to be enrolled without the employee. It does potentially mean that the employer is going to be required to newly enroll the employee and that dependent who the order is referring to if the employer finds that that order is actually qualified. One thing that I think is really interesting because I've never actually ever, I don't think, come across an employer who had this just on their own, but ERISA actually requires you to have policies and procedures for your qualified medical child support orders when you get them in the mail, meaning you get a qualified medical child support order in the mail. You're supposed to have this documentation about what you're supposed to do with it when you get it to make sure that it's qualified before you decide to go through with what the order requires. I've almost never seen it.
Fair enough. Yep, same here.
But they are good to have though, because there are actually some things that are required to be in the orders, and if they don't have the right information, you're not supposed to follow along with them. But to answer the question in a shorter manner, yes, that would be a qualifying life event to add coverage for the child.
All right, why don't we hand it over to Jenny then? Let her
Okay,
do a
cool.
final poll.
Wonderful. Well, thank you both. You both just shared so much knowledge today. We very much appreciate that. As mentioned, I do have one final polling question for our audience before we let you go here. I will launch that now. So if you were with us right at the top of the hour, you may recall we asked a couple of questions around your annual enrollment practices. And so we'd like to stay on that annual enrollment topic. And we're now curious about your communication strategies around annual enrollment. So please take a moment and let us know. And as you heard Amanda and David touch on today, that could be a good time to also just remind employees of the various eligibility rules. So as you are submitting those responses, I will remind you, we did record today's session, and a link to the recording will be available early next week from the benefits advisor who invited you to the webinar today. And that benefits advisor will also have a link to the presentation slides if you didn't get a chance to grab those already. And we do publish the results of these polls. We call the results a market check survey, and we put those out every month. So if you'd like to dig a little bit more into this topic around annual enrollment, certainly take a look at that market check survey when that comes out later next week. You can get that from your employee benefits advisor as well. And again, a big thank you to those benefits advisors and consultants who are partners of Assurex Global for making today's webinar possible. I'll also mention that if you had a question that we didn't get to today or just have a specific scenario you'd like to run by your advisor, please do reach out to that benefits advisor who invited you here. And they would also be happy to discuss your enrollment strategies as well. All right, polling responses have slowed down. I will close this out and share With everyone, it looks like the majority of our audience is really working to communicate kind of far in advance of that annual enrollment window. As you can see here, almost half of you are allowing more than 3 weeks for that communication to take place. So again, we appreciate your responses to those questions. Thank you again for joining us today, and have a great rest of your afternoon.